Well, hello and welcome to Newscentre. I'm Ashmit Kumar. The Union government has chosen to keep the judiciary out of the process of appointing election commissioners. A new bill introduced in Parliament this monsoon session proposes the appointment by a panel comprising of the Prime Minister, the Leader of Opposition and a Cabinet Minister. Now, the Supreme Court had ruled in the month of March that the appointment of Chief Election Commissioners and other election commissioners shall be done by the President on the recommendation of a panel which shall also include the Chief Justice of India. However, while passing the order, the court had termed the panel as a temporary measure until the Parliament enacts a legislation, a law on the appointment process. Well, to take this discussion forward, I'm now joined by Advocate Sanjoy Ghose. Also joining us in a bit will be Justice Ganguly, former Supreme Court Judge. Mr. Ghose, thank you so much for joining us, for being a part of this. First question, in March, the Supreme Court came out with an order that till the Parliament comes out with the legislation, here's a temporary mechanism. In this temporary collegium, the PM should be there, the Leader of Opposition and the CJI. And the caveat was that once the legislation comes out, that will be the way forward from that point on the Election Commission appointment process. On the face of it, there seems to be nothing wrong with it. Do you buy that argument?
Thank you, Ashmit, for having me. I don't buy that argument at all. For the simple reason that the way of a judgment of saying that this is until a law is made by Parliament has to be understood in context. The judgment is a constitution bench judgment which says very clearly in para after para the history of the election commission and how judicially independent it has to be made, how it has to be made independent of political parties and the executive. And ultimately, because of separation of powers, the court says that fine, we are giving these guidelines to fill the constitutional vacuum, the silence, and the Parliament shall make a law. And this is not the first time this has happened. As you're aware, in Vineet Narayan's case, this was done with the CVC. In Vishakha's case, this was done with the law of sexual harassment. Now, just because the Constitution bench says that this is an interim arrangement and it will be subject to the final law made by Parliament doesn't mean that the Parliament or the executive completely ignores the entire Constitution bench judgment and just focuses on that last sentence and this brings about a law completely doing away with the heart and the intent of the Constitution bench judgment, that is to insulate the Election Commission from executive interference by providing for a Prime Minister and his nominee to be on the majority in the selection body. So this is a complete subversion of the Constitution bench judgment.
Sure. Let me then ask a follow-up question. We've been in conversation with former Chief Election Commissioners. The version that they're giving us is that the legislation, the law on the appointment process, it was anyways being done by the executive exclusively. Now going forward, at the behest of the Apex Court, now that a legislation has come into being, this is entirely the prerogative of the Parliament, entirely the prerogative of the legislature, and that one should not have an issue with it. The only exception that the former Chief Election Commissioners have is that perhaps instead of a Cabinet Secretary, the government would have been better advised to have the Lok Sabha Speaker or the Vice President. Is that a rationale that perhaps would have managed to break the ice, so to speak?
The present Cabinet Secretary is on his third extension from the government. So you can imagine how independent that Cabinet Secretary, whoever it is, will be, who is dependent on extension after extension by the same government, by the same Prime Minister. Secondly, of course, it was things were done differently. But then we have a constitution, we have a Supreme Court, we have the Supreme Court, which is tasked by the Constitution to interpret provisions of the Constitution and also fill in silences in the Constitution. So it has filled in the silence through this judgment, which you are referring to, the Constitution bench headed by Justice Joseph, who is now retired. And it has clearly said that you have to insulate the Election Commission. And one of the ways of insulating is to ensure that the executive does not have the decisive say in this process. And the very fact that you're having a three-member committee which has the judiciary as an impartial party, and you have the opposition and the government, is a tripartite process. I don't see why there should be any problem with this. It should be hailed.
Sure. I'll just read out some excerpts from the March 2nd order of the Apex Court, the 5-judge bench. It says, founding fathers clearly contemplated a law by Parliament and did not intend the executive exclusively calling the shots in the matter of appointments. Another excerpt. A law could not be one to perpetuate which is already permitted, namely appointment at the absolute and sole discretion of the executive. The point that I'm trying to drive towards is that the apex court had taken exception to the executive enjoying exclusive powers in terms of appointments. Now, can the centre argue that, look, we no longer enjoy exclusive powers, now even the leader of opposition will be party to this exercise?
Well, I would like you to go into the history of the way other appointments are done, where, for example, under the Vigilance Act, where the opposition person is also heard. How many times is the wish of the LOP considered? So obviously, when you are setting it up in this form, as they have done with the ordinance in the Delhi, and now the bill passed as passed by both houses of parliament, where you put the chief minister along with the bureaucrats who have a majority, it is very clear what we are talking about. So, let's not, beat around the bush or ignore the elephant in the room. It's very easy to say that a law, for example, bans the rich and poor from both sleeping in the pavement. But who will it impact upon? So, there is something we can go by the literal interpretation when you say exclusively by the executive control, and we can go by the spirit behind that. And the spirit is that the executive should not have exclusive say. When you are putting in a committee two people who are directly under the control of one person, that is the Prime Minister, when the search committee is headed by a cabinet secretary who is dependent on extensions by the Prime Minister, where are you providing for independence?
Sure. Let me then ask you a follow-up question. Again, keeping in mind the very same excerpts, the point that you made about following the Supreme Court judgment in spirit and not in letter, with that in mind, the concern that the apex court had was obviously with respect to independence of the Election Commission and the influence that the executive may have on the Election Commission and the appointment process. The question I then want to ask you is, the Supreme Court had made its point clear in that March judgment. Now we have the legislation coming up in Parliament. Can it be argued that the centre is trying to do indirectly what was not permitted by the apex court to be done directly?
I think it's abundantly clear to everyone. In fact, this government has made it a habit, be it in this case or be it in the Delhi versus Centre case, to actually undo judgments of the Constitution bench even before the ink is dried on those judgments. So it is as clear to a 5-year-old as to what is happening. But well, that's how it is.
Well, just to build on that point, if this formula is to go forward, a collegium which would have a cabinet secretary, the leader of opposition, as well as the Prime Minister, will it be perhaps better suited, if not the CJI, then at least the Vice President or the Lok Sabha chairman finds a seat on this collegium?
Well, let's be very clear. Of course, law should not be made on the basis of immediate examples of what is staring at us, because a law is, of course, made in continuity. But however, as you see, it's not the cabinet secretary, by the way. It is the committee consists of the Prime Minister, a cabinet minister who is nominated by the Prime Minister, and the leader of the opposition. Be that as it may, now, if you're talking about the Speaker and the Honorable Vice President, I would say, in theory, yes, but the way we see today these offices functioning, if we really want to inculcate a confidence of the people, then I think all said and done, still the judiciary is the last bastion where the common man still has faith. So therefore, I don't see why there is such a aversion to including a person of the highest stature as the Chief Justice of India in such a committee. Surely no one can argue with the impartiality of the Chief Justice. I think such a move should be welcomed.
Sure. I thank you there for correcting me. I kept saying cabinet secretary. It's the cabinet minister that will be a part of this collegium under this new legislation.
But you're right. But
one of the reasons, perhaps, the reason I was perhaps confused is
there's a search committee first, which is headed by the cabinet secretary. So there is also a lack of independence there.
Indeed. Indeed. The search committee headed by the cabinet secretary, and it's the cabinet minister who finds a chair on this table, on this high table for appointments to the election commission. Let me also ask you another question, another aspect of this legislation which is under consideration. Another aspect is that the stature of the CEC and the election commissioners now stands reduced from that of a judge to a cabinet secretary. Is that a worry going forward in terms of the powers that it perhaps, the protection and the power that it provides to the election commissioners?
Well, it does, for the simple reason the pool of people who are chosen for these posts, as you know, are normally post-retirement people. So if you're not going to give them the status which is a little above what they retired as, their role as ultimately directing secretaries, directing chief secretaries of states in matters of election would somewhat be compromised. It is always better to give them a status higher than all the bureaucrats, because as you know, when the model code of conduct is in force, then they are the super in charge of all the bureaucrats. So it is better that they have a status higher than the bureaucrat. This is my personal view. But at the end of the day, as you know,
better that they have a higher status.
Sorry?
Mr. Ghose, we're running out of time, so I'll just end with one final question. Given the concerns and the anomalies that you've pointed out, do you see a legal challenge being raised in the top court?
Well, we are a litigious country. I am sure someone or the other will challenge this law, as most laws in our country are challenged. I don't think that it's a no-brainer. We are a very litigious country. People are out there challenging most laws. So yes, I'm sure that this law will also get challenged if it is passed in this form.
Sure. Right, Mr. Ghose. Thank you so much for joining us, for being a part of this discussion. Mr. Ghosh's view is that there are a few anomalies and that this bill, when it turns into an act, may well find its day in court. But with that, it's time now to slip into a very short break. Up next, building on the success of Ather Energy's best-selling 450 platform, the company has launched 3 new electric scooters at a starting price of 1.29 lakh rupees. Details on the variants when we come back on the other side.